Thank you so much for taking the time to watch this video. It is a dry video. I encourage you to have snacks, to have some refreshments, take breaks if you need breaks. It's absolutely fine. But it is important to make sure that you watch this video in its entirety before your next meeting with an attorney. I am not sure if you're going to have the pleasure of meeting with me or if I've already met with you, but the next meeting is where you're going to be reviewing your documents in length. And before you review those documents, it's important for you to understand what's going to be in the documents, for you to take a look at the drafts that we sent you after watching this video. And it's really going to help you understand what things that you need more clarity on when you meet with the attorney, what things you want to make sure that you get answers to. And basically also, this is also a video that is meant to just overall educate. We don't expect you to learn everything all at once. It's not easy things to grasp. So this is something that you can always refer back to and always use as a reference in regards to exactly what the heck it is that is in your documents and how do they work. Again, I don't think I have had the opportunity to introduce myself. You may have met with me already, you may have not. My name is Faiza. I am an attorney here at O'Connell Law, and it is my pleasure to be speaking with you and walking you through these important documents. And like I said, make yourself comfortable and take breaks as needed, and feel free to note questions so that when you meet with the attorney, you feel comfortable and you're able to make the most use of that meeting time. Thank you so much. So let's get started and talk about revocable trusts. I'm going to bring out my prop. Remember, think of a revocable trust as a container. As the grantor, you're the one that's creating the container. The trustee is the person that has access to the different assets that are put into the trust. Think of the trustee as the manager. And the beneficiary is the person that gets to enjoy whatever is put into the trust. So if you have a trust, you are, of course, the trustee and the beneficiary. You have full control, you have full access, and you can do whatever you want with what is in the trust. If you are married, then you and your spouse have your own trust, but you both have access and you both have control. So what I'm going to do is share my screen, and we're going to get started in reviewing a hypothetical client's trust. Let me share. So you can see the hypothetical client's Elmo. My daughter is obsessed nowadays, so this is who we're going to use. So the table of contents, think of this as your cheat sheet in regards to figuring out what is in your trust. Always refer to this when you are, looking at your trust and trying to understand what's in it. So think of each article also as chapters. Take it one chapter at a time. So Article 1 is talking about what kind of a trust it is. This is a revocable trust. It can be called a living trust. It can sometimes be called a grantor trust. It all means the same thing, making it clear in regards to the fact that you are the person creating it and you're also the person who has complete control and access. I'm going to flip to Article 1 so we can take a look at it. So you can see that it's making it clear right off the bat in regards to who is the grantor and who are the trustees. So in this situation, Elmo and Mrs. Elmo are the trustees. All right, this is a shorthand version of the trust, and this longer version is how the trust can also be identified with if someone wants to make it clear that both people are the trustees, aka both people are able to make decisions and have access to what's in the trust. It's making it clear that any third party can rely on this first chapter to make it clear that this trust exists, and that any property that is transferred into the trust is going to be controlled by the trust. And it's also making it clear that how exactly is your trust going to be funded. Funded is that funny word that means filling up the trust. So it's talking about that assets can be changed by their ownership or by updating beneficiaries to be put into the trust. And we also make it clear that there are certain things that we don't want owned by the trust. So once your trust is created and we help you sign it, and AKA you create the bucket, it's going to be an empty bucket, and we're going to make sure that the trust gets filled up. So, and we will be giving you instructions for that as well. As a grantor, you have the right to make changes to this trust at any time. You can amend it, you can revoke it. We hope you don't revoke it, but you can do that at any time. You can add assets to the trust, you can get rid of assets. You have full control of the income and the principal of the distributions of whatever is in the trust, and you have approval of investment decisions. Okay, and making it clear that as far as your status as a grantor, it follows what the IRS says. And again, this is where I have mentioned you don't have to file separate tax returns when you create a trust. It's all under your social, and things are done as you normally would do and how you normally are filing taxes. Article 2 is making it clear to the reader who exactly is in your family. So let's go to that. So for Elmo, he's making it clear that he's married to Mrs. Elmo. Anytime the spouse is referenced, it's referencing to Mrs. Elmo. Anytime it's referencing to baby Elmo, it's, you know, that's the child. They're also expecting another baby. So anytime an unborn child is mentioned, that is what is referring to. References are to descendants, are to children, baby Elmo and baby Elmo's descendants, also making it clear that if there's any deceased children, then of course it refers to their descendants as well. Article 3 talks about trustee succession and trust protector provision. So let's tackle trustee succession first. So trustee succession, obviously during your life, you have the right to change your trustees at any time, with or without cause. But if you ever became incapacitated, we're making it clear that if you are married, then your spouse is allowed to step in and be the sole trustee. Spouse can be the trustee by themselves, and then only if you and your spouse, or if you don't have a spouse, then it would be the next in line. Here, he is named Big Bird, and then after Big Bird, if Big Bird's also not available, then it's Oscar the Grouch. Upon passing, it follows the same order, where it's first for Elmo, it's Mrs. Elmo, then it's Big Bird, and then it's Oscar the Grouch. Baby Elmo is going to have a separate trust created only when both he and Mrs. Elmo pass away. And at that time, it's going to be Big Bird, who's the trustee. And then if Big Bird's not available, again, is Oscar the Grouch. Elmo has chosen 25 being the age of control. So when baby Elmo turns 25 years old, baby Elmo can make himself the co-trustee. He can kick out Big Bird and say, I'm the one who has full control, full access. I can make the one that makes the decisions. And he can appoint anyone to serve as co-trustee along with them. So we want to make it clear that, you know, what exactly, you know, can a co-trustee do? And remember, the co-trustee is important because that is what gives that creditor-predator protection to baby Elmo. But the beneficiary trustee, which is baby Elmo, because baby Elmo is the only beneficiary, they determine the extent to which the co-trustee shall participate in investment management decisions, as well as if they even want to be compensate the co-trustee. So let me know if you have any questions about this. Next, we're going to talk about trust protector provisions. And for that, I'm just going to go up here. It's going to be easier. So trust protector provisions, this is talking about in a situation where, let's say there was an external change by the law that will impact your trust. Of course, we will let you know, or any attorney you're working with will let you know there's a change, and you will have to come in and make that change to update it in according to current law. But what if you are in a situation where you either don't have capacity and are unable legally to sign your document, or you have passed away and have therefore can also not sign? You want to make sure that your trust flows the way you want it to. It goes to the person that it's supposed to go to. They get the amount that they're supposed to get to, that the trustees are allowed to have the access that they're able to, that the age of control applies. So if something happens and it impacts these things, then a trust protector is able, aka an attorney, is able to go in and make those tweaks to preserve your trust, aka protect your trust. They're not allowed to change the trustee. They're not allowed to change who gets how much. They're not allowed to determine the age of control or anything like that. Their job is to make sure that if something happens, that and the person who's created this trust is not able to sign to update it so that their intent remains preserved, that they're able to do that. It's a safety catch. Article 4 is talking about more detail about incapacity, so let's go there. It gives a definition of incapacity and is making it clear to the reader. So if someone wants proof to see if Elmo is indeed incapacitated, they're going to see that it's going to be a determination made by a physician. All right. And that, aka what this means in real life, that they're going to need a letter from a physician to show that Elmo has been declared incapacitated under the definition that is listed here. And of course, if this person signs a written opinion that Elmo is no longer incapacitated, then Elmo regains his capacity and can take control. Of course, under the law, the court can also determine if someone is incapacitated. And if you disappear or are in jail for 30 days or more, then the incapacity trustee also kicks in. So don't become jailed and don't disappear for more than 30 days. Article 5 is talking about now what happens upon your death. So what happens when you pass away? First thing, your trust becomes irrevocable, meaning it cannot be changed by anyone. The terms that you have created are set in stone because only you are the person that is allowed to make changes to it. The person who creates it, the grantor, is the person that is allowed to make changes to their trust. And once the grantor passes away, then no one else can make the changes. The trust protector, if ever needed, can change the trust to preserve the terms, but no one can change the terms. The trust becomes administrative, aka if there is any outstanding expenses, any medical bills, any liabilities, any funeral costs, any income taxes that still need to be paid, those things are taken care of first. We're also making it clear that if you have any life insurance that goes into the trust, again, also very important to, here's a really nice protection that's given to you. Any life insurance proceeds that get put into the trust is actually protected from creditors. Creditors cannot come after life insurance proceeds that are put into your trust. Again, making it clear that if any death taxes are owed at the time when you pass, of course, the person's going to take care of it. And that if there's any tax planning that needs to happen, that the person is allowed to do that. And if there's any charitable bequests, that those things get done as well beforehand. Article 6 talks about disposition of tangible personal property. A really long word, seems complicated, but it's actually talking about something, it's actually regarding something very simple. Tangible personal property is anything that you can physically touch. It's the stuff that you own that fills your house. This is the jewelry, the painting, the light fixtures, the furniture, things like that. And it's talking about how that is supposed to be disposed of. So when you come in, you are going to be signing something that's called an assignment of personal property. An assignment of personal property is saying that whatever it is that you own now or in the future, you are putting it into the trust. So it's the trust that controls how things are supposed to be disposed of. AKA, no matter how much something costs, it should never have to go through probate, no matter what the value is. All right. It's also making it clear that if you want to leave something to someone specific, that if you have signed this document, the personal property memoranda, this is the document that is saying that I want to make sure that my daughter gets this necklace. All right, you would put necklace, you would say it's my daughter, the name, the address. If you put the asterisk, that means that daughter has to wait until me and my spouse passes away. Otherwise, if there's no asterisk, that just means I die and my daughter right away is supposed to get this necklace. This is for anything that you want to make sure that either one, your kids don't throw away, or you want to make sure that kids don't fight over something, or you want to make sure that if you have grandchildren that you leave them something, or other family members or friends. This is where you're going to list those tangible personal items. And the great thing about this is once you date it and you sign it, it becomes legally valid. So you don't need attorneys, you don't need it to be notarized, no witnesses. You can change this form at any time. You can change it 10 times a year or once a decade. And the instructions in the trust say, trustee, look to see if I have completed this, and whichever one is the most recently dated one, carry that one out. Otherwise, just carry on. So there is no requirement for you to fill this out. If you have not filled it out, then guess what? It's going to happen. Everything goes to whoever is the primary beneficiary, and then it's going to go to the next in line. And then they can figure out what they want to do with it. This is just saying the personal property memoranda that if there's specific things that need to go to specific people, is making sure that that happens. So if you are married, then you are probably doing tax planning. So if you are doing tax planning, then this is making it clear to the reader that this is one of the purposes of this trust, and aka you're preserving that right to use that coupon upon the first of you to pass. Article 8 and Article 9 is now making it clear that at the time when if you are the first person to pass away, then those two subtrusts can be created. If you are not married, please skip this part that I'm talking about. It does not apply to you. So take a look at this when you are reviewing the trust, and if you are married, is basically this is that language that we talked about in previous meetings where there's going to be two separate subtrusts. One of them is going to be filled with exactly what that amount is, the threshold amount, and and it gives ability so that it gets taxed. And everything else is everything else. It's a way to carve out that exemption amount. Now, you'll see that there is there's some spouse remarriage language, okay? This is if that contingency plan, that if a spouse gets remarried, spouse has to enter into a prenuptial agreement that says that whoever the new spouse is, the other third party, the new person, they cannot have access to the deceased spouse's trust. So that's what it's making that clear on. Article 10 is now talking about what happens when both people pass away. All right, or if you are not married, then obviously who is the primary beneficiary? So let's go there. And if you are a single person, then the article, the chapter number, it might be different for yours. All right, but the language inside is going to be similar, if not the same. So Article 10 is making it clear that everything is supposed to go to descendants. So in this situation, right now, baby Elmo is an only child. So everything is going to go to baby Elmo per stirpes. Per stirpes means if baby Elmo is not living, then equally down to baby Elmo's children. Her stirpes means basically my bloodline in equal shares. It's making it clear that whoever baby Elmo's trustee is, so maybe it's Big Bird, maybe it's Oscar the Grouch, that they are supposed to, or maybe by the time baby Elmo inherits, baby Elmo is the trustee. It's making it clear that baby Elmo, as much income or principal is needed for baby Elmo's trust, it can be used. It's meant to be used for health, education, maintenance, or support, and is making it clear that the trustee, you are desiring that baby Elmo's well-being and happiness is preserved and provided for, but you also want to make sure that the trustee considers other known resources before making these distributions. AKA, if someone has a scholarship, trustee, make sure that you take advantage of the scholarship. Don't just rely on a trust. Use a scholarship and then, tap into the trust. But we also understand and make it clear that the principle of the trust that is created for baby Elmo may be exhausted in making distributions, because you want to make sure that, again, that baby Elmo is provided for. Now, if you have any specific language in regards to what the money should be used for or shouldn't be used for, it's going to be in this section. Upon baby Elmo's passing, obviously monies cannot go to spouse, cannot go to any creditors. It's making it clear that it goes down to baby Elmo's living children per stirpes. It's also making it clear that if baby Elmo has no children, then it's supposed to go to baby Elmo's nearest lineal ancestor, who is also a descendant of mine. So that means if baby Elmo has siblings, then it's supposed to go to siblings. All right. So if they don't have children, if she doesn't have children, then her share is to equally go to her siblings. Also makes it clear that if there are any descendants of a child that has passed away, of course, they are to be treated the same, and they can be administered in the same kind of terms that were set aside for baby Elmo. Article 11 is talking about that remote contingent, that worst case scenario, that everyone that you've named has passed away. So if you're married, your spouse has passed away. Your child or children have passed away. Your children don't have grandchildren. Everyone is gone. It's remote. So in this situation, Elmo has stated that everything is supposed to go one half, who would inherit if my spouse had passed away, and one half to people that would have inherited in accordance to state law if I had passed away, aka 50-50 to our closest living relatives. That's what happens if we pass away. So for you, you may have chosen charities, you may have chosen specific family members, or maybe friends, or maybe a combination for that worst case scenario, but that is where it is listed. I always say that after the remote contingent, now we're talking, the rest of the trust is just kind of the basics. All right, making it clear that obviously if any underage individuals who you have not accounted for, so grandchildren, great-grandchildren, people that are not named specifically in this document, if someone underage inherits, then obviously their inheritance is to be put into a trust as well. Their guardian is the one that's going to take care of it for them. And if someone's incapacitated in the future inherits from you, that their inheritance is to be put into a special needs trust. Most people, if you are incapacitated, you're receiving some kind of benefits. You don't want a random inheritance to come out of nowhere and disturb these benefits, which is why we kind of, again, attorneys' jobs to think of every worst case scenario and make sure there's a contingency clause for everything. So that's what that's talking about. Retirement plans and life insurance policies are two things that you are not going to be changing the ownership of. We're going to be giving you guidance in regards to how to update the beneficiary, so that upon passing, how does that asset get put into the trust after death? This is making it clear to the reader. Don't forget that these things exist and exactly how are they dealt with. For Article 14 and Article 15 is talking about what exactly is the trustee allowed to do and how are they supposed to do it? What are they what permissions do they have? And it's giving that guidance. So randomly, so for example, no court proceedings. It's making it clear that they can take care of your banking stuff. It's also names a lot of things in here, you guys, that probably don't apply to you. Oil, gas, and mineral interests, farming and ranching operations. You may not have this right now, but we put it in because we don't know at the time of incapacity or at the time of passing what exactly it is that you are owning and that a trustee may need to step in to take care of. We don't know which state you're going to be living in. We don't know what assets you have. And we want to make sure that whoever is the one who's responsible, it's going to be easy for them to step in and take care of things. The last article is just general provisions. It gives definitions and things like that. So that is a revocable trust. Now that I've gone over it, take a look at yours, make note of questions so that when you meet with myself or another attorney to review your documents, that you have some specific questions related to your own situation in regards to how the trust works. All right, thank you so much. All right, let's talk about the will now. So I'm going to share my screen again, and we are going to walk through the will. All right, so here we have Elmo's will. So remember, if Elmo has a trust, then the trust is what has the instructions in regards to what happens upon Elmo passing away. But if things are not put into the trust, then it is the will that will control. So again, making it clear who is Elmo married to, who is Elmo's children, and making it then under Articles 2, talking about who inherits. If Elmo has a trust, then Elmo's trust inherits, because you want everything to go in instructions with what the trust says. You want that if you have children, that protection for the kids in those trusts that are created for the kids, with the trustee managing until they are of age. Article 3 talks about who is in charge of the probate process, who's personal representative. It used to be called executor, now it is personal representative. It means exactly the same thing. So Mr. Elmo has nominated Mrs. Elmo. If Mrs. Elmo is not able to step in and do the job, then it would be Big Bird stepping in. The will is also the document that names legal guardian for your children, if you have young children. So you can see here that guardian is also named. Elmo has nominated Mrs. Elmo, and after Mrs. Elmo is Big Bird. All right. Article 4 is now talking about exactly what powers does the personal representative have. Again, we don't know what assets are going to go through probate, if any, and we don't know what you're going to own at the time when you pass away. So we want to make it clear that this person, the personal representative, has access and the ability and power to take care of anything and everything that you may have. Making it clear that any powers granted by the state is, they're allowed to act on it. Okay. If a personal representative wishes to distribute directly to a beneficiary, so if it's a spouse, they can they can just inherit themselves, that's fine, or to the trust. And then Article 5 is instructions to the court. All right, we want to make sure that whoever is reading this knows that they have to keep the job easy. So no bond needs to be posted for the personal representative. Administration does not need to be supervised. If someone pays for something out of their own pocket, they're allowed to be reimbursed. They're allowed to be reasonably compensated. Reasonably compensated is set by the court. It is not hundreds and thousands of dollars. It is more like whatever, right now, for example, is between $25 to $100. Someone has to set the rate, not as a professional, but as they personally, are doing the job. Ancillary means if you have any property in a different state other than the one that you're living in, then your personal representative is allowed to take care of those assets that are in that other state and open up probate. And then last article is, again, the trustee of your trust is going to make sure that any taxes, any outstanding claims, funeral costs, expenses, Those things are going to be taken care of by the trustee. And then the last article is just definitions again. We want to make it clear that no one has any confusion in regards to what a word means, what a sentence may mean, what an article means. So just clearing that all up so that no one can ever have any confusion. And that is your will. So it's a much simpler document as compared to the trust, but a very important one nonetheless. So let's talk about the durable power of attorney. What is it? It is the document that kicks in if or when you ever become incapacitated. So let's just dive right in and let's talk about it. I'll share my screen again. So just like before, we have a hypothetical client, Elmo, and I'm going to walk you through Elmo's power of attorney. So it talks about who is going to be the first person who steps in if you were not able to take care of yourself as a person, aka make arrangements for yourself. Let's say you need some kind of care, you need to be put into rehab, or you need nurses to come to your house. This is a person who's going to step in to make sure that you are well taken care of, able to sign any contracts on your behalf for your care, and of course, take care of your stuff for yourself. Now, whatever is put into the trust takes care of that, right? Because we talked about incapacity if someone has a trust and how that would work. This is now for those individuals that either don't have a trust, or for those individuals that have a trust, but there are things that are not put into it, right? And there's some things that will never be put into a trust. Maybe the beneficiaries are updated, but not the ownership. If that first person that you've named is not available, then it's going to be a backup, right? So then if you're not able to do the job, the person's secondary person who's stepping in, they're not able to step in, then it goes to the next. There is something called the default of designation. If all the people you have named are all unavailable, so they've either passed away, are sick themselves, or just don't want to do the job, then that is when Okana law, or our successor in interest, is able to put someone in that position. This prevents the court from stepping in and deciding who should be put in to take care of you and your stuff. This is kind of this, again, another level of protection. So we do not become your power of attorney. We are able to put someone into this role. So any prior attorney, power of attorney no longer applies. This is now the latest and greatest one. So the power of attorney goes into effect if either of these circumstances, which I'm about to discuss, happens. If two licensed physicians ever determine if you are incapacitated. Some people have a private determination, and they name specific individuals in their life who they trust to make this decision that they have now reached the point of incapacity. So that's who would be listed. If you don't trust a specific individual, or you don't feel comfortable having a specific individual with this kind of authority, that's when it's going to be two licensed physicians who will have to come to an agreement that you are now no longer able to take care of your stuff. So it says here that it can be due to prescription medications, due to age, illness, drugs, or any other cause. A court can always determine if you're incapacitated, or if you are ever jailed or disappear for more than 30 days, then this also kicks in. And the last reason, the last way, I should say, that a power of attorney can be triggered is if you yourself decide, I want this document to get triggered. I no longer want to be the one taking care of things. I want the person that I have named in this document to step in and take care of my stuff on my behalf, for my behalf. If that is the case, then there is this document in the very back of your power of attorney. The certification of authorization by principal. When you come in to sign this document, you're not going to be signing this particular page, the certification. You're going to be signing your power of attorney, but you are not going to be signing this last page. The reason is because this is the document where mentally you have capacity. No one could ever say that, you don't have capacity, but it's your own personal decision that you want to take a step back and have someone step in. In that situation, you would sign this in front of any notary and it gets triggered. So that's for those situations. People will ask me, why would I ever need to do this? When is there a time? This is if or when you ever need it. It's in the back of your power of attorney for emergencies. If you ever need to trigger it, a lot of people will do it if they have either reached an age where they're way too elderly, they have capacity, but they're elderly and they don't want to take care of their stuff anymore and be the one in charge. Or if someone gets a very terrible diagnosis where they have capacity, but they know they're going to be, involved with treatments and they're going to be ill and there's surgeries, then they're going to sign this as well, so that if they're unable to take care of the stuff, there's at least a seamless situation where the next in line can be able to step in and take care of everything. So what is in this power of attorney? So we talked about how it's triggered. Now, what exactly is this person able to do? This document is filled with power to this, power to do that. All right, the powers are all there, and some you may think make sense, and some you're like, this doesn't even apply to me. That's okay. We put in everything because we just don't know that when this is needed, what exactly is going to be needed to be taken care of at that time. So there may be many things in this document that do not pertain to you and your circumstances, but that's okay. We rather have it be full and encompassing, as opposed to something that is very restrictive, because you don't want to give a hassle to your loved ones to go to the court and get a specific permission. So you'll see here, so some of the things you probably even think about, I just randomly came on this page: power to provide for my recreation and travel, power to provide for support of dependents. This is very important for those that have kids. You want to make sure that there's no gap in making sure education and things like that are being paid for. So then you have power regarding insurance, you have power regarding retirement plans, you have power to operate businesses on your behalf, power to manage digital assets. It goes on and on. I was just randomly scrolling. Digital assets, just because I'm on here, this talks about anything that is online. So this is talking about all online stuff. So read through this, scroll through this, and let me know if you have any questions. But you'll see there's just plenty of powers in here. And if something doesn't make sense, I'm happy to talk about it when we meet. Now let's talk about healthcare proxies. Just as a reminder, a healthcare proxy is a document that gives guidance to healthcare professionals in regards to who you would want to step in to take care of you and all your medical decisions if you were unable to speak and talk to the doctor yourself, and say what you would want in regards to treatment, etc. So I'm going to share my screen and we're going to walk through a healthcare proxy. Okay. So again, it just tells who you are, where you live. Remember, for all of these documents, the address if you ever move in the future, it's not going to invalidate your document. Anywhere where your address is listed is just to give further identity to who you are. Your address is forever going to be linked with you, right? So for some clients, if it bothers them a lot after they move, we're happy to update documents and have the new address be put in, but just know that just because you move and your address is something different, it's not going to invalidate this. All right, so 1.01. This is designating that person, it's also called an agent, who is going to be stepping in to make sure that you're taken care of. This is the person talking to the doctors. This is the point person making sure that you're getting the proper treatment, etc. So typically there's a first, then there are backups. Okay, so now at this part, this is where I tell clients that so far I haven't mentioned who should get what document. This is a document that you should give a copy to the people that you've listed as agents. Just because if there is an emergency, they should already have it on hand. I strongly, strongly encourage you to please give a copy of this to your primary care physician so it's put up into the cloud as part of your medical record. People sometimes ask me, what if something happens to me and I'm taken to a different hospital? Like, how will they have it? Just know that even if family members are not able to get somewhere quickly, or you don't have a healthcare proxy yours in your hand, doctors and hospitals, the protocol is that they will always reach out to primary care physician to get access to your medical records. It's important for any treating physician to know what medications you're on, what are your prior diagnoses, what's going on with you. So they always get that information. And if this is part of your records, how fantastic. Okay. And when I always recommend too, is before you give it to the doctor, handwrite people's phone numbers. Okay, so in this one, let's use this as an example. So I would tell Almo, make sure you handwrite Big Bird's cell number. Make sure then you also handwrite in Oscar's, the Grouch's cell number. You would just add it right here. Okay, you just write it in, and the one with the phone numbers, give it to the doctor. This healthcare proxy is not going to expire, and it terminates either if you revoke it or if you pass away. You are giving your agent the authority to do acts all related to your personal care, residential placement, and medical treatment, anything that agent determines to be appropriate. Okay, and we're making it clear, including but not limited to the things that are specifically named in this document. This is a very robust document, but there could be things that could be missed, and we just want to make it clear that this person is allowed to make decisions about everything. Okay. For as long as you lack the capacity to make or communicate healthcare decisions for yourself. We're also making it clear that as long as you have capacity and are able to partake in your own medical treatment, your agent is instructed to discuss with me the specifics of any proposed decision regarding my medical care and treatment if I am able to communicate in any manner, even if it's just blinking my eyes. All right. And if it just talks about exactly what the agent can do in regards to consent, and if the agent cannot determine a treatment choice I would want, then the agent should make the choice for me based upon what agent believes to be in my best interests. Okay, you're making it clear you want to leave your family and friends and people who are taking care of you with assurances of love without the burdens of guilt or conflict. And you're hoping that the agent is going to be able to make, again, we make this list, but it's making it clear it's not just pertaining to this list. So medical treatment, surgery, amputation, CPR, administration of pharmaceutical drugs, all those things are included. Now we're going into more detail. They're authorized to select a facility for your nursing or for your long-term care or for rehab. They're allowed to make arrangements and do whatever is necessary to be able to keep you in your own home. Majority of our clients, when we talk to them, they want to stay in their own homes for as long as possible. It's very important that we put this in a healthcare proxy for this reason. But we're also making it clear that for as long as it is reasonable under the circumstances, okay? You realize that your health can deteriorate and it may become necessary to have round-the-clock nursing care if you remain in your personal residence. So You're just you're directing that your agent has the authority to do what they need to make this happen, as long as it's reasonable. Your agent has access to your medical information, medical records. I'm going to be talking about the HIPAA as well, but this goes hand in hand with that. It's making it clear that it's including but not limited to physicians, dentists, chiropractors, therapists, etc. It goes on and on. This person is allowed to employ and discharge healthcare personnel, nurses, doctors to take care of you. They're allowed to make decisions about your pain relief. They're allowed to consent to psychiatric treatment. They're allowed to grant releases. Again, talking again about the HIPAA, that if you have signed the HIPAA, you're granting the agent the power and authority to serve as your personal representative for all purposes that are listed in the HIPAA. If for some reason something goes to court, you're telling the court that you are nominating to be your spokesperson, the guardian. You nominate the person that's listed on this document. Any third party can rely on the instructions and decisions of your agent in regards to your treatment. And God forbid, if something bad happens to you, your agent is allowed to sue on your behalf. They are allowed to go to court and get a judgment. They're allowed to ask for damages. You're releasing your agent from any personal liability. If your agent pays for anything out of their own pocket, you are saying that they're allowed to get reimbursed for that. Copies are just as effective as originals. If you travel or you move to a different state, this is making it clear that this instrument, this healthcare proxy, is to be honored in any jurisdiction. You reserve the right to revoke this either orally or in writing. And if you have any prior older healthcare proxies, once you sign this one, this is now the latest and greatest one. So that is your healthcare proxy. It's a very, very important document, which is why it's not just one page. There's multiple pages to this. Take a look, read it, and again, let me know if you have questions on it when we meet. So we talked about the healthcare proxy, and now we're going to talk about the HIPAA. The healthcare proxy tells the doctor that this is the person who is going to be making my medical decisions. This is the person you have to go to ask, should I do this or should I do that? The HIPAA is a document that gives the permission for that individuals that are named in your healthcare proxy to get access and to your records, and that thus be kept in the loop. This is the document that otherwise there are strict privacy laws and things in place for your medical records. No one is allowed to call the doctor and ask them what medications you're taking, what are your medical conditions. No one is allowed to know any of these things. Only you have the right to know this. This document is saying that the individuals that you have listed in your proxy, or just in general, anyone that you want to make sure that they're allowed to be kept in the loop, they are allowed to be kept in the loop. We have it including but not limited to a bunch of different people, so physicians, chiropractors, pharmacies, ambulance services. I mean, there is a whole list here. And you will see that this document actually terminates 2 years after you pass away. Why is this? So actually 2 big reasons. So one reason is the reason why we put all of these different things in here, and 2 years, it terminates 2 years after you die, is because often people are having to reach out and get information because they're dealing with medical bills. So of course it's important for the healthcare proxy agent to be kept in the loop so they can make well-informed, wise decisions about your care and your treatment, but then also just making sure that the bills that are coming their way, that they're legit And if they feel like they need to get more clarity, they're able to reach out to these people and to these institutions and get that clarity that they need. So that's why even after someone dies, there's still bills and things that need to be taken care of. The other thing is if some harm has been done to an individual and someone has opened a lawsuit, your healthcare proxy agent on your behalf, you want to again give them some time to be able to do that. So then that also is why it terminates 2 years after your passing. It's saying that you understand the information that's in this document by signing it, and that any authorized people that are listed on this document have the right, again, this is just making it clear that they're allowed to sue. So they have the right to bring a legal action against anything, not only if harm is done, but if someone refuses to accept this authorization. This document can be copied, it can be given to multiple places if needed, and each copy will be considered just as good as an original. You're waiving this document by signing it, you're waiving any right to privacy regarding this, and it conforms to the laws of the United States and Massachusetts. So again, this will apply anywhere, but it's just making it clear how was it made. So with this document, the other one, the healthcare proxy, I said, please give it to those agents and give it to your doctor. This document, do not give it to anyone. Let them know that it's part of your estate plan and you have it, but you don't need to give it to your doctor at this time, and you don't need to give it to those individuals. If and when an emergency is needed, if someone needs to gain access, they have this and they'll be able to use it at that time. All right, they have this meaning they know where they can find it along with your other documents, and then they're able to get it from there and give it to anyone that they need. But you should not be giving this to individuals today, right now. Almost at the end here. So last document that we're going to discuss is the living will. All right, so this is a document that is also a healthcare document. You may have decided that you want this, you may have decided that you don't want this. If you decided that you did not want this and you are not planning on signing this, go ahead, please fast forward this next part onto the next, fast forward and move on to the next part of this video. For those that are planning on signing this document, please continue on and listen to what I have to say about it. So I'm going to share my screen. This is the document that says that if the doctors have determined that death is imminent, you're in a permanent vegetative state, there's no hope, you do not want your dying to be artificially prolonged. That is the key right here. You do not want your dying to be artificially prolonged. You're directing that life-prolonging procedures be withheld or withdrawn. If that situation happens, you're refusing to consent to any life-prolonging procedures. It has to be that your death is imminent or you can no longer experience a meaningful life. All right, you wish to die naturally with only the administration of medication or the performance of any medical procedures deemed necessary to provide you with comfort or care or to alleviate pain. So, as a reminder to our lovely clients, this is a document that a doctor cannot rely on, and it is not binding in Massachusetts. So if you have this, it does not guarantee that this is what's going to happen. In Massachusetts, the healthcare proxy agent, that is the person who has the last say. That's the person that the doctor is going to be looking at and saying, what should we do? This document is meant for guidance for that person. So it's to help alleviate some of that burden one can really feel if the doctor is asking them to make a very difficult decision. But just know, in the end, it is their decision. Okay, so let me know if you have any questions on this, and happy to discuss it more at our meeting. And thank you so much, you guys, for hanging in there with me and hearing me discuss all the important estate planning documents. We are now at the very end of this video, and I hope you found it informative. I want to leave you with some final thoughts. So when you come in and sign your documents, you are going to be going home and with everything in this binder. All the originals will be in here under separated tabs. So there's a tab for everything. The will is going to be the only thing that is going to be in plastic sleeves. That is because, and the plastic sleeves in the binder as well, but the reason for that is simple in the sense that Massachusetts judges just don't like 3-hole punches and they don't like staples. So we're just doing whatever we can to keep them happy. So that's why that document is in such a special way. I encourage our clients to please utilize this binder kind of as a one-stop shop, right? If there ever is an emergency, you should encourage your family members. First of all, you should tell the people that are named in your documents, where can they find this document, binder, excuse me. Where is this in your house? We do not encourage safety deposit boxes because those are the first things that go on lockdown if someone is incapacitated or has passed away. So if you're going to put it in that, make sure that someone has the access or the key. But honestly, we're not the biggest fans. If you're going to keep this in your house, which majority of our clients do, just make sure that if it's in one of those fireproof, waterproof, fire and waterproof safe boxes, that it is someone has a code, the people named in the documents have the code, there's a key, there's a way to get in. Otherwise, just let family know where they can find it. You're going to be going home with the copy, the original, but we're also going to be sending you copies, full copies of your signed documents after you go home, about a week or so after. All right, so you will have both things, originals and a full set of electronic copies. So like I said, a one-stop shop. So not only are your estate planning documents going to be in this binder, I really want you guys to put anything that you feel like, if something happened to you, what would people need to know? People meaning spouse, if you're married. Not everyone knows everything, right? Or your kids, or those friends and family members that you have named in your documents. Okay, they have access to your bank accounts. They have access to take care of your medical needs. But where are your bank accounts? What are those account numbers? Who is your doctor? What's your health insurance number? All that information. There's a place in the back of the binder that says other documents. Utilize that and put everything that you think is important in the back there. So pet instructions, children's pediatrician information, your doctor's information, any emergency contact numbers. Nowadays, everything is in our cell phones, but if people can't find our cell phones, then, or are not able to get into our cell phones, then what? So just whatever you can think of that you feel like people would need to know if there was an emergency, put it in the back. You can always make copies too. So for example, I have a copy of my driver's license, my passport, my birth certificate, my daughter's, our health insurance cards, all of that stuff is also in the back of my binder. Like I said, one-stop shop. Estate planning is not just making sure that all your documents are in good order, but also making sure that, just life in general is in order, nice and organized. And if there ever was a catastrophe, an emergency, that there is a plan in place and there's no headaches for those people that are left behind. So again, thank you so much for taking the time to watch this video. I genuinely, wish you the very best. Either you're going to be meeting with me or you're going to be meeting with another team member, but thank you again. It means a lot to not just me, but the entire O'Connell Law team that you have taken this so seriously and you have watched this video. We encourage you to please reach out, not even during meetings or after you've signed the documents. At any time you have questions, reach out. We are happy to always provide guidance and clarity on the estate planning documents that you are soon going to be signing. Thank you so much.